Wait a minute. Wait, 1 minute. Are you telling me it's only Tuesday? Then why does it feel like Thursday afternoon when the weekend's been canceled and I got ahead of me nothing but tough sledding? Oh, that's right. It's because today is day 53 in United States of America versus Joseph Biggs et al., also known as the Gilligan's Island trial. The prosecution rested yesterday. We reserved on behalf of Mr. Biggs, our opening statement until the close of the defense case, the state's case, rather, the government's case. And so I was able to give an opening statement after 2 months of evidence. It presented an interesting conceptual problem. And the government, put me on notice that they were going to object if I commented on the evidence. And I did, and they didn't object. And I trimmed it back a little bit so that Judge Kelly wouldn't spank me too hard in the jury's presence. But, an opening statement is typically a party's presentation to the jury of what they think the evidence will show. And when it's given prior to the receipt of any evidence, an advocate acts at his or her peril. You say you think that, the government is going to show that at 2:00 on the afternoon of July 5th, whatever year it was, Joe Blow walked into Fancy's bar and shot Mac 6 times in the back of the head. And he did so because Mac was banging his wife or whatever the theory of the case is. And, then the defense stands up and says the evidence will show that, this guy came in loaded for bear and he shot in self-defense for fear that he would be shot. And then the parties put their cases on. And their cases either conform to the evidence or not. In this case, we'd already seen more than 2 months of evidence in trial. And so we weren't painting on a blank canvas. And I was able to comment on the government's case while forecasting what I think our case would show. I argued for about 45 minutes. There were no objections. I think the jury was receptive to it, although it's really hard to know with a DC jury just what is going on. One humor note, though. This judge does not permit speaking objections. He doesn't want you to argue when you object. You have to object and give a quick statement that alerts him of the basis of the objection. Under Rule 403 of the Federal Code of Evidence, a party can object to evidence if it's unduly prejudicial. That is, if its prejudicial impact outweighs whatever probative value it has, either because of jury confusion, waste of time, or any of a number of factors. So a shorthand throughout this trial have been people standing up saying, "Objection, 403." Now, I don't think the jury knows what 403 is, or at least they didn't know prior to the trial beginning. But I looked at them and I said, we've been here for a couple months, and I'm guessing this trial has changed your perspective on the world. Pause. Look. Wait for them to wonder where I'm going. I mean, for example, when you go home, a long day in court, maybe you got a headache and your spouse says something to you that you don't want to deal with. I'm guessing some of you have said, "Objection, 403. Am I right?" And they all laughed, and it's probably true. But anyhow, so we're into the defense case today. We have 2 half days this week: half day Tuesday, half day Thursday. Jurors have medical issues in the afternoon. We don't know who, we don't know what, and then a full day Friday. I suspect the case will end next week, and then we will move to closing arguments. The case could be in the jury's hands as early as middle to late next week, and deliberations will begin. Another group of January 6 defendants were convicted yesterday. These were oath keepers in yet another oath keepers trial. And, it is sobering to stand in the well of a court arguing on behalf of a J6 defendant in a courthouse where no one who has gone to trial with a jury has been acquitted.
Yeah, that's tough. That's very tough.
And so I'm
very 1,000 defendants at this point, and more forthcoming. So
yeah, so it's a bracing environment, and it is what it is. I mean, we're going to go in, we're going to fight it, and we're going to do our level best, and ask the jury to acquit because we think the jury should acquit based on the law. We'll see what happens. What in the world? Yesterday when we ended, we just nodded in the direction of Alex Jones, and we thought we'd follow up a little bit more today because people seem extraordinarily interested in Alex. The New York Times ran a front page story on Sunday, about Alex Jones and the Sandy Hook families. And the headline, I think, says it all. The Sandy Hook families are fighting Alex Jones and the bankruptcy system itself. That headline is a tell. Somehow we have made the Sandy, and there sits one of the Sandy Hook parents in the middle with this beatific look on her face, basically standing for all that is good, true, righteous, and beautiful in the world. And how is it that Alex Jones and now the evil court system has abused them? And I mean, enough already. The Sandy Hook shootings were terrible. Mr. Jones's comments about them were actionable, and he was defaulted, and a judgment was awarded. But at some point, we have to stop making martyrs of the Sandy Hook families and say to them what we say to every group of people who are involved in a tragedy: mourn, but then in the end, pick up your bed and walk. The story suggests that somehow the families are being abused by the bankruptcy system. And one of the authors of the story is a woman named Elizabeth Williamson. Elizabeth Williamson has made a cottage industry out of Sandy Hook. She's written a book about the case, Sandy Hook and the Battle for Truth. She appeared to cover the trial, she was giddy in the courtroom during the proceedings. When Mark Bankston, a Texas lawyer representing the families, came into court to observe at one point, she gave him a hug, and you would have thought the two of them were high school sweethearts, reunited after decades of absence. And there is this sense of camaraderie among the Sandy Hook supporters that they alone represent righteousness and that they're fighting evil. And if we would all just bow in the direction of the good, we'd all be better off. And now it's not just the evil Alex Jones, but the evil bankruptcy system. And, I'm not sure I buy it. The bankruptcy system is designed to present equitable relief to people who have problems with their creditors, and it's designed to save businesses, to permit them to keep operating rather than being liquidated under crushing debt. The Sandy Hook family's lawyers made it clear that their objective in the litigation was to stop Alex Jones and to crush him. And now they awaken to the possibility that these ridiculous judgments they've received without proof of damages, because they weren't required to prove damages. I will be taking that these judgments are being looked at in the bankruptcy court as farcical, and that Jones is being able to continue to operate without being destroyed. And if you read carefully through the New York Times story and pay attention to this character Bankston, he is one of he's a personal injury lawyer out of Texas who hooked onto the Sandy Hook cases and is seeking a sense of significance by being the white knight against the dark star of Alex Jones and misinformation. I mean, he acknowledges in the article that their objective was to stop Alex Jones, and they're realizing now that they may not be able to. That he may get relief, the very sort of relief that the bankruptcy courts offer, and continue on in business. Neither judgment that led Jones to pursue bankruptcy has been neither appeal has been perfected yet. There will be an appeal in Texas of the $50+ million verdict awarded there. There will be an appeal in Connecticut of the $1.4 billion judgment awarded there. I'm handling the Connecticut appeal. I'm in touch with the lawyers who are handling the Texas appeal. And I think there are powerful reasons to believe that Jones will win both. In Texas, there was a cap on punitive damages that the judge just decided to ignore.
Yeah.
And I think that the Texas Supreme Court is likely to look at that and say, no, and reduce that verdict down to a manageable $4 or $5 million. In Connecticut, Mr. Jones was defaulted. He was defaulted for failure to comply fully with discovery or to the plaintiff's and judge's satisfaction, but he didn't willfully refuse to comply at all. And so the question is whether a default, that is the loss of an ability to contest liability, is warranted or was an undue penalty in that case.
That is part of the basis for the appeal in the Connecticut case. No.
Yes, it is. It's one of the primary bases. And then there were a series of trial court evidentiary rulings, which as further sanctions made it possible, in effect, for the Sandy Hook lawyers to sell a hoax to the jury. And that's the thing that's most disturbing about the New York Times article. It's reported that Jones is worth hundreds of millions of dollars. He's just not. The evidence that suggests he is came because he was not permitted to contest numbers that in the Connecticut case were pulled out of thin air. The plaintiff's lawyer said, "Look, we were able to show over a 10-year period that he had as many as 500 million social media clicks. That he's that big an influencer. Although they didn't put any dollar estimate through evidence before the jury, a medical, in the form of medical bills and whatnot, for the plaintiffs, they said, look, for each click, give us $1, per plaintiff, for $2
I wish we
a
could have
day.
$1,000 a day, Norm.
Yeah.
For every view that we get on this video, give us $1. That would be great if that were real.
And so in the end, the jury ended up awarding $1 billion, which is of compensatory damages, and the judge added $400 million of punitive damages. These numbers are fantasy land numbers. They bear a relationship to the evidence that a dart thrown against a board does to what, I don't know. But I mean, this was not a calm, unpassionate, dispassionate jury assessing evidence. It was people ginned up in a sympathetic show trial, and that a judge permitted and fostered with a series of evidentiary rulings that are unheralded, unprecedented in Connecticut. And so I do predict we will win that appeal. I also think that the bankruptcy court itself may just say, look, this is just ridiculous. We've looked at the trial record, and there's nothing fair, just, equitable, or reasonable about this judgment. And so I think the Sandy Hook families are going to be disappointed in the end. Mr. Jones has offered a lot in the bankruptcy court. He has offered them a plan that might contribute about $45 million, I think it was, a year over a certain number of years to them, or maybe it's $45 million over a certain number of years.
The article makes mention of this, but you can see here the writers say, which lawyers for the families immediately dismissed as laughable and riddled with financial holes, even though the number is 43 million. And it's difficult to even reason through being able to laugh at an offer like that of $43 million when the Connecticut court awarded $1.4 billion.
Yeah. Well, I mean, what's laughable and riddled, what do they say? Laughable and riddled with financial holes are the verdicts themselves. And once these appeals are heard and the public gets to see how these numbers were arrived at, I don't know that there'll ever be a backlash against the Sandy Hook families, but there could be, because we all, in our own ways, come to terms with irreconcilable grief. A parent dies. We suffer ill health. We suffer reversals. I'm not saying that's the same thing as having your first grader murdered at school. I don't want to be accused of that. But the bottom line is that somehow you learn to pick up your bed and walk through life's tragedies. In the Sandy Hook case, the New York Times is making martyrs of them and basically saying to the world, stop. Make sure they get all their money. Collapse the bankruptcy system if necessary, because it's not fair. Mr. Jones should be made to suffer, and it's obscene at this point.
Yeah, no, I agree. I also think that these writers are doing a massive disservice to the families themselves in and amongst the multiple appeals that are going on right now. Putting out this article, over the weekend and slamming this notion that the bankruptcy court is being pushed to its limits is ridiculous, because there are credible appeals that are forthcoming. So for this sort of pressure to be put on in the public view of Jones after these judgments have been rendered and in the process of appeal that runs, I guess, parallel to this bankruptcy proceeding is just ridiculous. It's setting unreasonable expectations all over the board in a really, sort of unconscionable way.
Here's the tell on Elizabeth Williamson. During the Sandy Hook trial, the corporate rep was a young woman named Brittany Paz, and her cross-examination lasted some 3 days. And to convey to the jury how tedious it had become and unbearable, I sat there for a while with my head back, eyes closed, just like, oh my God, how long is this going to go on? And Elizabeth Williamson quickly tweeted from the courtroom, Alex Jones's lawyer is asleep. And I later confronted her. I said, no, I wasn't. I was trying to convey to the jury board, no, you were asleep. And so this creepy, supercilious nitwit had decided which side she was on. She decided which piece of rhetoric would advance her narrative, and she decided to pursue it even at the expense of the truth. And her reporting reflects that as well. Now, clearly, I'm a partisan. I'm Alex Jones's lawyer. I believe in his right to speech. I think the default was an outrage, and Judge Bellis's conduct on the bench was a discredit to the bar and an embarrassment to the state of Connecticut. She's let the world know what she thinks of me by suspending me from the practice of law. I'm not objective about her or the case, but make up your own mind. And once the appeals come in, just take a look at the briefs if you care to. We'll post them here, certainly, and you can decide for yourself whether the real hoax in Sandy Hook's right now is perpetuation of the claim that somehow these families are owed $1.5 billion as a result of verdicts that were the result of abuse, grotesque abuse of judicial.
Well, one last parting shot for these for the writers of this article. You see here, Mr. Jones founded InfoWars in Austin, Texas around 99. He broadcast his theories from his house and began producing feature-length conspiracy-themed videos. That's just one. They opened the article by saying the InfoWars conspiracy broadcaster, Alex Jones. The lack of self-awareness around the meme of Alex Jones was right and the timing of this article is not lost on me, and it shouldn't be lost on any serious person reading this, that the two writers of this article, Elizabeth Williamson and what is that, Emily Steele, right? It's as if they want to pretend that society writ large is not watching many of these conspiracies that Jones has espoused over the years since 99 seem to just come to fruition in remarkable velocity in the last several years. And they try to do that in an effort to just shine a light on this issue of the Sandy Hook stuff. So
no, I get it.
Tremendously ridiculous to me.
I try not to become too much of a partisan on this, but Jones's perspective is that the Sandy Hook people were used, to take him out because he's a voice shining a light on globalists, this, that, and the other thing. And he's been right all along. I'm not going to go quite that far, but I am going to say that the Sandy Hook cases have been misused and obscenely so.
I want to acknowledge the chat real quick before we pivot here, because I know we're going to pivot hard into DeSantis and Trump, but we've got all the regulars, all the usual suspects in the chat today. So great to see you all. Bathtub Liquor says, you guys just need to sell some supplements. Norm's reading juice. I think we could actually get on that. I like that idea. More of a style drink, right?
Those of you who have trouble sleeping at night know the soporific power of a good book. But here's the problem. You can't sleep, so you turn to a good book, and suddenly you're sleepy. The good book beckons, and you want to read it. So we are going to sell you Norm and Mike's Miracle Juice. That's right. For $29.95, you stick a little bit of this in a glass of orange juice, drink it, and even the footnotes in a scholarly tome suddenly start to glow, while you might find yourself reading a law review article on the statute of frauds, finding yourself wondering, how did I miss this all of my life? Writing at 4 o'clock in the morning a note thanking the author for writing it. Norman
How
Mike's
does
Miracle Juice
work in the state of Florida?
Take $29.95. Yeah, we're on it. Or better yet, let me bring in my guest sponsor. Hi, this is Alex Jones. And if you have trouble sleeping at night because of the global conspiracy, because of the fact that there are people consuming children, drinking adrenochrome, and that Q has suddenly been silent while the Chi-Coms take over and George Bush stumbles down the runway of every airplane he ascends, take this juice. Take it from me. I don't sleep. I'm Alex Jones.
And I'm not the silliest nitwit. Don't be one. We got Thinking Man says something interesting. He says if they awarded smaller money judgments, they would be more likely to get the money. I agree with that. I think that we're so beyond the pale of reason in this case that it's distracting from the fact that that these families could get paid. Right.
Well, here's what's funny. The family set out to destroy Jones, and they got judgments that they thought would. And the bankruptcy court has said, no, they won't. And so now they have to decide, now they need Jones to work in order to get paid. And if they try to move in for the kill, he'll reform and continue to work. And so the good news is that Alex Jones continues to speak. The bad news is the plaintiffs are frustrated.
That's
the
right.
worst news is the New York Times is becoming their bitch and their whipping boy and soiling the front page with a story that's making a mockery of the American judicial system.
That's right.
While we're on that topic, the American judicial system, what up with DeSantis and Trump?
Man, so DeSantis yesterday finally made a statement, and it was something that was widely covered. And among the conservative pundits and talking heads and those that are more cultural commentators, I liken Cernovich to more of a sage in that respect. You know, he has very strong opinions on Trump as well as on DeSantis. And we talked a lot about that yesterday, so I don't want to retrace our steps too much. But the basics of that are, if we just look at Cernovich as sort of the paradigm through which to see this issue, I think number one, Cernovich assumes that, and I don't think I'm wrong in saying this, but Cernovich assumes that DeSantis is going to run for president. Right.
I think that's right.
Right. So that's one thing that's not being discussed in and among the back and forth about the substance of whether DeSantis handled it well, is handling it well, or is not handling it well. One thing that is interesting about this is there is a widespread expectation that DeSantis is running for president in 2024. And for that reason, he should be taking a position outwardly on this issue. So DeSantis speaks. I won't recast the entire speech, but he basically took some sort of pot shot at Trump, talking about hush money to a porn star. And I think that actually dates back to like 2006, Norm, if I'm correct on that. But he did say that he was not interested in entertaining, I guess, the wayward whatever of a Soros-funded DA, which has now thrown the internet into a frenzy, right? Cernovich would say that he was way too soft. He was speaking as a moderate president circa 2015, or a moderate presidential candidate circa 2015. There's a part of that criticism that just resonates with me. I don't know how it resonates with you, Norm. On the other side, however, there are many people who are saying that DeSantis has handled this masterfully, and that he is handling it the way that he should, not just for the optics or for the political prospects, but for the legal prospects. So that's what we want to focus on this morning, right? Or what are the legal mechanics of state-to-state extradition? I asked you that this morning, and I seem to have found something that at least is a question that we can pose to our audience. And if there are Florida-based attorneys that have more insight on this question, I would love to know. But I did find one statute in particular that seems to give DeSantis some additional discretion on the issue of extradition. But before we get too far ahead, Norm, will you recast the legal mechanics of what extradition is in a context of state-to-state detainment?
Yeah, so if you are in state A and state A issues a warrant for your arrest and you flee to state B, the extradition clause of the Constitution imposes a duty on B to return you to A. But that would not be the case here. Donald Trump is not in Manhattan and so he's not a fugitive. He was not fleeing New York to Florida. He's a Florida resident, and let's say that New York comes out with a warrant for his arrest, and that is a warrant for an arrest for a felony. Florida can't simply send its law enforcement officers into New York to arrest Mr. Trump. They don't have jurisdiction or power to act in Florida. What the process is there's an interstate compact or agreement on how to extradite a person. That is, to remove a person from one jurisdiction to another. So the prosecuting authority in Manhattan would have to present to the governor of New York an extradition warrant, a governor's warrant for Trump, and it would summarize who he is, meaning Donald J. Trump, the crime charged, whether it's a felony under New York law, and where he currently resides. And those papers have to be in a certain form. If Governor Hochul of New York signs that warrant can then be presented to the governor of New York, and if that governor signs it, there'll be a show cause hearing in Florida. Donald Trump would have a right to appear in Florida to contest that the paperwork wasn't in order, that it wasn't a felony, that it wasn't a crime, let's say, or that he's not the actual Donald J. Trump described. And if all those formalities take place and it's a felony and it's then he should be extradited. And the language in that treaty makes these ministerial acts for the governors in question. And so DeSantis is now roughly in the position, in my opinion at least, that Mike Pence was in on January 6th. Pence was the president of the Senate at that point, and he convened a joint session of both the House and Senate to count electoral votes. And his responsibility was to preside over that proceeding and to preside over any disputes that arose. If one senator and one congressman, one House member, raised an objection to a vote, the Houses went to their respective chambers and they had up to 2 hours to debate whether to accept the slate of ballots or not. That was the process. And then there'd be a brief debate. And if the House and Senate convened and combined decided to accept it, he shall count that vote. And that's a ministerial act. He didn't have a lot of discretion. DeSantis, in my opinion, doesn't have a lot of discretion either. And so I think that if presented with a valid New York warrant, it would, I believe, be unlawful for him not to sign it as a matter of politics. And so I think that Donald is playing to the cheap seats once again. I continue to believe that the prudent course for Trump, and even the wise political course for Trump, if there is a warrant for his arrest in Manhattan, would be to go to Manhattan himself without being extradited. And I think that putting DeSantis in the Pence position on January 6th, we saw how that worked out for the Donald in January 6th of 2021 and his supporters. There's no reason to believe it'll work out any better this time.
Well, two counterpoints for you. I put on the screen what I believe to be the active statute on point for this specific question, because if you leave it to Twitter, you will find people who say, as you do, Norm, but with categorical certainty that this is a ministerial task. There's no discretion afforded to the governor. He must abide the extradition request as made by the other state. However, there's another side of this that because there is a, similar to contracts, there's what's known as the Uniform Commercial Code. Most states adopt this Uniform Commercial Code that will dictate the terms of contracts dealing in the sale of goods, such that if contracts are not written and whatever, that the law will imply certain terms to contracts whenever they come into dispute. Similarly, and there's the same thing with custody arrangements, right? There's jurisdiction, state to state issues with custody and those types of hearings. So states will sign on to these things where there is a uniform way of handling these situations, but not every state does that, and or some states have more specific laws and regulations that they abide. And this is one that I discovered this morning in looking through the 2022 statutes for the state of Florida. And it says, governor may investigate case. When a demand shall be made upon the governor of this state by the executive authority of another state for the surrender of a person so charged with crime, the governor may call upon the Department of Legal Affairs or any prosecuting officer in this state to investigate or assist in investigating the demand and to report to him or her the situation and circumstances of the person so demanded and whether the person ought to be surrendered. So that seems to afford Norm some discretion over whether to honor the extradition. And I don't want to make this like make a mountain out of a molehill if I'm the ignorant attorney that isn't aware of how Florida law applies. However, this seems on the plain face of the law to afford DeSantis some discretion. And here's what I'll use to support that. I'm going to take this off the screen. Representative Jim Jordan, I think yesterday, published the letter that he sent to Alvin Bragg, the district attorney there in the Manhattan District Attorney's Office that's at the forefront of this. I'll put it on the screen here. So this is obviously a congressional request for certain documents, and they list it here on page 3. All documents and communications between or among New York County District Attorney's Office and the U.S. Department of Justice, blah, blah, blah. All documents, communications center received by former employees referring to or relating to President Donald Trump, and all documents or communications referring or relating to the New York County District Attorney's Office receipt and use of federal funds. And what he's done here with this letter, now a lot of people, and you'll see over here in the comments on the right hand side that people are saying, just ignore it, blah blah blah, in support of Bragg. But the basis of this letter seems to be, framing wise, to call this a pretextual prosecution, right? A politically motivated prosecution, and then substantively to talk about the federal investigation that was done, the unreliability of Michael Cohen as a principal and as a witness in this investigation, how many times he lied, et cetera, and then some notion that the Manhattan District Attorney's Office was perhaps communicating with the Department of Justice on this and is using federal funds to prosecute a state case that the DOJ itself declined to prosecute back in 2019, and also taking advantage of a loophole in the statute of limitations, which would allow one cause of action that would have a 2-year statute of limitations to be increased to 5 if it's raised up to a felony. And in this case, it seems to fit the bill. So, Norm, I guess I would just counter with that Florida provision. And then now we seem to have, as of yesterday, something from Congress telling District Attorney Alvin Bragg, cut it out.
Well, I mean, if I'm Alvin Bragg, I'd write Jim Jordan a note saying, yes, we receive federal funds to administer local laws. We don't receive federal funds to have a congressperson evaluate our charging decisions. That's uniquely a matter of state law and under well-settled principles of federalism. Thank you for your assistance, but we decline to discuss. And that would be as much as I would write to him. And then when he demanded that I come to his committee to testify, I'd send an aide, and that aide would have a lapel pin that says GFY. And if Jordan asked what it said, I'd say, you really want me to say that, sir? Yes, my boss told me it says, go fuck yourself. I mean, I think Jordan is overreaching here. Candidly, Mike, the politicization of this arrest on both sides is deeply distressing to me. It doesn't serve the republic. I do believe it's pretextual. I believe that Donald Trump has every reason to win it. But this jurisdictional tug of war and attempt by politicians to hitch onto this train, it's a ride to nowhere. Trump should not force the extradition issue. He needs to get DeSantis out of it. I mean, I can tell you that the Center Street courthouse was effectively closed down today. I spoke to somebody in Manhattan yesterday. The only business that's expected to take place in that courthouse today is Donald J. Trump. Cases were moved a day earlier to Monday, or people were asked to come in Wednesday. I'm told you can't get into that building without a Secret Service permit today. Something is going on. Donald Trump ought not to play the extradition game. He ought to go and address the charges on their merits. And if, in fact, this is pretextual, flimsy, there are statute of limitations charges, defeated in open court on a motion, and then turn around and sue if you can. But I'm just, candidly, I'm distressed. This strikes me, this new national mantra that we have, that Donald Trump is a victim. He's right up there with the Sandy Hook families as far as I'm concerned. There are serious issues about how to live together that we need to address. Donald Trump is becoming a national embarrassment, a joke, and a sideshow. And so is Alvin Bragg. Okay, so put Mickey Mouse and Minnie Mouse in the same courtroom and let them tear at one another. But it's just, and then move on. That's my view, and I'm sticking with it.
Well, I'm interested from a legal perspective as to what authority the governor would have to look at a case like this. I think that was my question. Yes.
No, I see that. He has the right to look into it, but I don't think he has the right to say I disagree with the charging decision. I think that would be bad for the republic.
Well, and I'm quoting again, and whether the person ought to be surrendered. That's an analysis. And I know that we have those 3 prongs that most people are putting out there, pursuant to whatever the U.S. code provision is. I don't remember the number. However, state law is more specific on this point, and it does seem to afford something. So I'd love, if anybody knows a Florida attorney that wants to opine on this, more in favor of me, more in favor of Norm, please connect us with them. This is,
so DeSantis decides not to extradite. Donald runs for president, but he can't step foot in New York. I mean, at what point, do we want to call this the United States of puppetry? I mean, at what point do we just pick up our beds, walk grow up and go about the business of living. Donald Trump, I know you're listening out there because this podcast is huge. Just go to New York, turn yourself in, fight it out on the merits, use this as a stage for your campaign. But the extradition fight is a bad fight.
Yeah, well, I don't disagree. And Thinking Man 61 says that's the goal, make Trump a cartoon character and unelectable. I think that the more that this stuff happens, because again, I think I may have said this yesterday, but just to say it again, we've got the J6 investigation that's ongoing for him. We've got the Georgia election issue that's still ongoing with him. We've got the classified documents and the raid on Mar-a-Lago that's still ongoing with him. And then we have this like really petulant issue sort of germinating out of New York and the Manhattan District Attorney's Office that somehow has taken center stage over everything culturally and politically.
Yeah, and it's just Donald Trump's ability to suck the air out of a thinking man's room is not something that I appreciate. Donald, get a life. Okay.
Happy birthday to Barron Trump as well. I saw it was his birthday.
Happy birthday to he. He'll never live to be 33.
I think Laura Loomer said, Barron Trump is 17. Donald Trump is 76. Together they are 1776.
Oh, God. Let's go. I got to get to court. Objection.
Overruled, Norm. Overruled. Do it again. Do it again. Do it again.
Objection. I need to be heard.
What rule are we talking about here?
403.
403. What's 403? Can you ask the jury? Overruled. All right. Thank you all for joining. Catch us on Spotify, Apple Podcasts, Google Play, Overcast, etc. Please put a thumbs up on this video if you haven't already, and share it with your friends and family. We're enjoying this. We've got a lot of people in here live this morning. Please continue circulating that around and help us grow. Make America think again. We'll see you tomorrow, Norm.
Ciao.